Hi, everybody on the internet. I'm Alan Lenczycki, a Libertyville, Illinois attorney. I want to talk about some legal information about orders of protection. Okay, this is part of my Order of Protection, a series of videos. They're really, really important. Orders of protection are often suggested by the police when there is a domestic violence incident. It's one of the most common ways that litigants will get into court with an order of protection. One is eligible to receive the protection granted by an order of protection if one is a family or household member of somebody who's abused or harassed them. Okay, order of protection is actually very, very similar, though slightly different from a no stalking order. A no stalking order is abusive or harassing conduct, like a pattern of conduct more than one time. So it's got to be two or more times where somebody who maybe you even don't know is abusing you. That's a no stalking order. So somebody who's following Britney Spears or something like that, that's a stalker. Everybody knows what that is. The no stalking statute is very, very similar to the order of protection, but in the order of protection, it's a family or household member. They may be stalking you. They may be abusing you. Family or household member includes boyfriend, girlfriend, ex-boyfriend, ex-girlfriend, somebody I met on Tinder one time, probably, okay? As long as they had a dating or household relationship, those are people you qualified to get protection against, okay? Anyway, what are the grounds for an order of protection? So the grounds for an order of protection is when you have been, or one has been, abused or harassed. This is very, 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 very broad. In my experiences, judges will often grant what I think are maybe weak orders of protection, where somebody was just kind of vaguely threatened, like you'll get what's coming to you. And sometimes judges deny orders of protection. It's all very, very fact specific, even when the order of protection petition, I think, is strong, with strong evidence for other reasons of equity or whatever. But the judges have lots of discretion. But if you are abused physically, I'm punched, sexually assaulted, whatever, weapon, threatened with, I'll kick your ass, I'll burn your house down, I'll sexually assault you, those types of threats, those abuse and harassing threats, that is going to be definitely grounds for an order of protection in Lake County, Illinois, and probably other places too, like Cook and McHenry. I can't speak so much about order of protection courtrooms in other counties. I don't usually go to those counties, but you're going to have to understand that each judge has wide discretion and can grant or not grant an order of protection as he or she sees fit. Anyway, when an order of protection is granted, when it is granted, what are the enforcement issues involved with it? Well, okay, let's say you've got an order of protection on your behalf against another party. If that other party violates the order of protection by calling you, by emailing you, by coming within 500 feet, whatever the terms of the order of protection contain, if they violate that, then they're subject to getting arrested, okay? It's a civil order of protection, but we call it quasi-criminal because it stimulates a criminal case. Normally, if I violate a court order in a civil case, like a divorce case, I mean, it's not great, but they could hold me in contempt and use the court's civil powers to, whatever, make me pay attorney's fees or even take me into custody. But if you violate the civil quasi-criminal order of protection that that's been granted against you, well, now you're looking at a Class A misdemeanor. The cops will come over and arrest you, and then further violations have ever-increasing penalties. We'll talk some more about those penalties and other nuances of the order of protection later on in this video series. Thanks very much for watching.